now to our interview segment. My guest is the president of the Nigerian Bar Association, Mr. Augustine Alege, Senior Advocate of Nigeria. Recently, the bar launched a stamp and seal policy. The bar also had some of its members on the streets monitoring the just concluded general elections. So I started by asking him what lessons he thinks the country can learn going forward.
The first thing that we take from these elections is that violence is never an option in resolution of disputes. It is also crystal clear that Nigerians determine their leadership not on the basis of religion, not on the basis of tribe, but essentially on the basis of performance. People need to learn that your vote is your right. It is the equalizer of all Nigerians. President, billionaire, millionaire, thousandaire, gateman, homeless, jobless, destitute, we all have one vote. We need also critically to look at our voters register. The results in the presidential election with all the large voter turnout we saw was tilting at about 30 million. Yet our voters register has 68 million. That is something that we need to look into very seriously. Because when you have a bloated voters register, it is a recipe for rigging. We must also all understand that the issue of card reader came after the voters register. So the voters register may have been inflated by some unscrupulous politicians hoping that to be a basis for them to declare higher numbers. We had, it was the first time a card reader was used. We had massive card reader failure. And if you know how long it takes to verify per person, you wonder how in an election where in most parts of the country INEC staff did not get on site until about 9 o'clock, voter card reader challenges, and yet we declared humongous figures. So for me, we must look inward at all those things with the hope that going forward we will have better elections. I think the lessons learned in these elections will help to develop our democracy, make it stronger, and make it better.
We had violence rear its head in some states. Now, the issue of dealing with electoral offenses and offenders, how do you think that INEC can deal with those issues going forward?
The little skirmishes, I'll call them little because they were restricted to certain states. It was not widespread. There were some flashpoints in Lagos, there were flashpoints in Rivers, in Abia, in Akwa Ibom, I think some flashpoints in Ekiti, Kogi, but they were really, for this time, limited. The reason why we still have these acts of electoral violence is because, or electoral offenses, because there's no concerted effort to prosecute electoral offenders. We have since 2010, under our pro bono platform, offered to partner with INEC to deal with this issue. And the issue of funding, yes, lawyers no charge professional fees, but they have expenses they run in doing this, has been a stumbling block. And I wonder why INEC's budget for legal matters is being expended on election petitions.
Not on prosecuting
and not on prosecuting
electoral
offenders. In an election petition, INEC is a nominal party. And the Supreme Court has even said INEC should not or should be discouraged from appealing because it must remain an impartial, unbiased arbiter between both candidates. So if, for example, myself and yourself went for an election and I had a petition against you, and then INEC appealed on my behalf and the court ordered a rerun, then INEC will now organize that election between me and you again. Will you have confidence? And when you see that INEC is taking so much to pursue civil matters, where the winner of the election or the contestants have lawyers, the contesting political parties have lawyers, and INEC is a nominal defendant. Our view in the NBA is that if INEC has a budget for legal matters, it should expend 80% of that budget going after electoral offenders and expend 20% because in pursuing electoral offenders, INEC should be a principal party.
Did you hear the joke that there won't be much work for lawyers going forward because losers are now conceding defeats to winners, and so the election tribunals will not be busy? That would be one of the good lessons.
I heard the joke. I do not think that lawyers call for election petitions. I know that lawyers are happier when their cases are moving in court, because normally when you have election petition season, other cases don't move.
Other cases suffer.
Other cases suffer.
Because the judges that handle election petitions are pulled out of that
the state high courts and the various courts. Okay. So now there are few election petitions. It means we still get compensated because our other cases will move faster. So it's a win-win situation. Firstly, we will be beneficial, like all Nigerians, of a good electoral system, of good government, of a stable democracy. But the fewer election petitions, it means that our regular courts will work better. So we are not really losing in that way.
Let's end with the stamp and seal for lawyers that you recently introduced.
Have you got your own?
No. I have heard about it. I have read that there will be a separate one for those in public practice and for those in private practice, and that the essence of it would check quacks in the profession and all of that. It's laudable, but how are you going to ensure implementation? How are we going to put checks in place and make sure that it's not just like any other policy that just comes and goes?
Well, the first thing is that the stamp and seal is nothing new. It is contained in the Legal Practitioners Act, the Rules of Professional Conduct 2007. It's been there.
Oh, so we've just not had it?
We've just not put it in force.
Okay.
That is the first stage. The second stage is for all of us who practice law to understand that there will be healthy competition between us if we are competing at the same level. But where we are competing with quacks and we keep saying things have gone bad. A client came to my chambers, I charged 100,000, he left, and later he said somebody charged him 10,000. You're not competing against a lawyer. Your competition is a quack. And the 10,000 is good enough for him because not the lawyer. So we must all understand that. I'm making that as an example. We must also understand that we have government corporations who pay as much as 6 billion out yearly to foreign law firms to do work in Nigeria.
Work that Nigerian lawyers can do.
Work that Nigerian lawyers should do. Work that law says belongs to Nigerian lawyers. Work that is related to Nigerian assets. And it's laughable that these are persons who have sworn to uphold the Constitution of Nigeria.
So we can't compel them to give this work to Nigerian lawyers?
Well, before now, those documents, whether they were prepared by Nigerian lawyers or by foreign lawyers, were accepted. But what we have done, for example, is wherever such a document turns up without the seal of a Nigerian lawyer, it's not admissible. Not a valid document. It can be registered. It can confer title. For example, power purchase agreements, liquidation and sale of company by BPE. You will see the adverts in the newspapers calling for foreign law firms, although we have no law in Nigeria. But I'll tell you that under my watch, anybody that it comes to my attention, that he tries it, I will apply to the Attorney General for a fear to prosecute him. We all need to understand that stamp and seal protects our collective good from the top to the bottom. If you go to the front of the Ikeja High Court, you see women sitting down there with typewriters doing affidavits.
Yes.
The rule states clearly that affidavits must have stamp and seal. You go to a court and you see a tenancy agreement prepared by an estate agent who's not a lawyer, and it is tendered and the court admits it. But now it will not happen again.
So meaning that you're carrying all the stakeholders, judges are keying into this?
The CJN was present when we launched it. He has given he openly pronounced that henceforth any document without stamp and seal will be inadmissible. The only thing he said that we must give breaking time for people to get their stamp and seal so that this thing will work. And we're writing to all chief judges, all attorneys general, all land registries, marriage registries, anywhere and everywhere a legal document is used, we need to drive this. And this is part of rule of law. You know, for example, you go to the embassy to do an interview. It hasn't happened to me, but I've seen it happen. And you bring an affidavit and they say, oh, take it away. We know you can do a Nigerian affidavit for anything.
Yes.
It's an insult to all of us. But we are saying that for henceforth, each affidavit will carry the name of the lawyer. So when they sit in the embassy and they are uncertain that this is a fake affidavit, then they need to call that lawyer up or call the MBA up. And the lawyer has deposed an affidavit on behalf of Mr. A or B, or he has prepared one and put his stamp and seal, and the facts are wrong. That is a one-way ticket to the district committee. From there you go. You can go and do trading or farming. We cannot allow our collective welfare and well-being be put in jeopardy by a few hungry persons.
And it's on that note we end this edition of the program. You can watch this and past episodes on our YouTube channel. Do also feel free to interact with me via email, Facebook, or Twitter. I am Shola Shieli. Thank you for watching.